Hello friends, how are you? Myself is Dr. Jinesh Soni. I am an advocate. Basically, we are going to discuss the case of divorce based on adultery. Section 13 of Hindu Marriage Act inter alia provides a ground to take divorce on point of adultery. But the concept of adultery is not defined in Hindu Marriage Act, in IPC, in Bharatiya Sakshya Adhiniyam. But basically, Section 13 of Hindu Marriage Act inter alia allows for divorce on point of adultery. So first of all, we have to understand what adultery is. Adultery means whenever your opposite spouse, means if your husband, your wife, inter alia engaged in sexual intercourse with someone other than you during the continuance of marriage. In that scenario, it would be the instance of adultery. For example, if your wife is engaged in sexual intercourse with someone prior to marriage, then it would not be the instance of adultery. Now the concept is clear to us. So mere kissing, mere having a meeting, mere having a phone call would not be the adultery. Apart from that, it is one of the most important ground for divorce in Muslim law, in Indian Divorce Act, in Special Marriage Act. Now the important question arises, how to prove the adultery? Adultery can be proved with the help of evidences. It might be direct or circumstantial. As far as the direct evidences are concerned, it includes the consent adulterer and consent wife red hand trap. In that scenario, when you caught your wife and the consent adulterer red handed while being engaged in sexual activity, in that scenario, the same would be the direct evidence of the instance. If in course of that proceeding an admission is made by the adulterer or by your wife or both, the same would be admissible as evidence as per the protocol of section 15 and 121 of Bharatiya Sakshya Adhiniyam. Apart from that, with the help of CCTV camera, hidden camera, spy camera, the factum of adultery could be proved. But such type of evidences inter alia comes within the preview of electronic evidence. And apart from that, there might be instances wherein someone inter alia submitted you the photographs or videos of your wife showing that she is inter alia indulged in the activity of sexual intercourse with someone. In that scenario, with the help of electronic evidences, the instance of adultery could be proved. But to be noted that it is not very easier to stand the factum of adultery with the help of electronic evidences, because in said scenario, the wife might take a stand that inter alia the said evidences are going to infringe her right to privacy. But to be noted that recently we are having multiple judgments wherein it is specified that such evidences would not infringe her right to privacy, and that's why you could submit the same and could rely on same so that the factum of adultery could be proved. Apart from that, we are required to have the opinion of cyber expert so that the admissibility of the concerned electronic evidences could be stand. For this, we have to rely on section 63 of Bharatiya Sakshya Adhiniyam or section 65B of Indian Evidence Act, and we have to rely on an important judgment of Honorable Supreme Court titled as Ram Singh versus Ram Singh. Citation is EIR 1986, Supreme Court, page number 3. So up to that point, we are very much clear what is adultery and how to prove the adultery with the help of direct evidences. Now we are coming on circumstantial evidences. To be noted that circumstantial evidences are weak piece of evidence. It is not very easier to prove the factum of adultery based on circumstantial evidences, because we have to follow the principle of Honorable Supreme Court that says that in a case based on circumstantial evidences, the chain must be complete. There should not be any breakage. If there is any breakage in that scenario, our case would fail. Apart from that, the evidences of the concerned spouse, means of our wife and the adulterer, spending time together in a private place or a scheduled place. And apart from that, you might stand the case with the help of evidence that there is non access of you to your wife, but despite of that, she got pregnant. And apart from that, with the aid of factum of childbirth, by emphasizing on factum that the said birth took place when you are having no access to your wife. In that scenario, the factum of adultery could be stand. But to do the same, a strong medical evidence is required. Mere conjecture, mere surmises, bald statement cannot be a helpful instance to you to be succeeded in a divorce case based on the point of adultery. Apart from that, you might take this stand your wife is having STD, means sexual transmitted disease. But to be noted that the said pleading is weak piece of pleading because STD might be caused due to certain other reasons. So that pleading might not help to you. And apart from that, if you are having evidences that your wife used to visit places of ill reputation, the same might be a relevant factor, but the same might not be an absolute factor to be succeeded in a case based on point of adultery. So basically, if you are having evidences, for example, letters written by adulterer or by your wife, emails between adulterer and your wife, text message showing the vulgar content between the adulterer and your wife, and apart from that, you are having hotel records or ALN records showing the trips taken together by them. These evidence might be relevant or helpful to stand the case of adultery. Apart from that, you may also rely on testimony of your neighbor or friends showing that the inter alia saw the concerned adulterer and your wife at a private place. So every evidence is having its specific value, but it depends on the point of gravity and quality. So if the evidence is quite clear and it is totally helpful to draw conclusion in that scenario, it can be considered to have a point of success in your case. So it is requested to all of you, do not put up your case based on bald statement or on mere surmises and conjecture. If you are doing the same, in that scenario you could not be succeeded. And apart from that, if you are having the evidences that your wife inter alia purchased gift for the adulterer and vice versa, and to sustain the said averment you are having the bank statements or credit card statement, then the said scenario can be used as evidence. So we might conclude that the burden is on the person who is making the allegation, but to prove the same he is not required to stand the case beyond reasonable doubt. He can do so by relying on the formula that is called POP, means preponderance of probability. The concerned person is required to submit the possibilities on record by the virtue of which conclusion of adultery could be drawn. Bald statement without supporting evidences could not help you to be succeeded. And apart from that, the appropriate evidences must be on record, the chain must be complete, and apart from that, there should not be any manipulations in your submissions, to be noted that. Apart from that, you have to specify what are the potential consequences you had suffered by such act of adultery committed by your wife. You have to show that due to the said act of adultery committed by your wife, the marriage had been broken down and there is no chance of any restitution, and apart from that there is no chance of any repair, and you have not condoned the act of your wife. The said pleading is to be done as per section 23 of Hindu Marriage Act. In addition to this, you have to be very much clear on the point that do not act in the anxiety. First of all, you have to collect the facts. In addition to this, you have to collect the evidences and have to review the same so that you could know whether the evidences are admissible or not. You may take the advice of expert lawyer to understand the legal implications and the best course of action, and apart from that, you are required to give notice before filing the case. It is important because if you are giving the notice and your wife is submitting a reply, and in the court proceeding, in the written statement, she is submitting a reply which is totally inconsistent with her previous stand. In that scenario, you may also rely on section 119 of Bharatiya Sakshya Adhiniyam for having the adverse inference. So basically, in conclusion, we may say that adultery is one of the most important ground for divorce. Apart from that, the direct evidences are important, but if they are not available, then the case could be proved with the help of circumstantial evidence and testimony of witnesses. That is called ocular evidences. But before filing a case, specifically when it is based on adultery, it is requested to have the opinion of cyber expert in case the entire evidences is based on electronic perspective, and apart from that, after having the proper brief with evidences, it is requested to consult a lawyer who is expert on the subject so that we may know what are the nature of evidences, whether they would be admissible or not, and apart from that, we may consider all the consequences before filing the case, and that might be helpful to you to understand the success in your prospective case. So I think that I am totally able to cause all of you to understand the basic concepts with the help of suitable illustration. See you in the next video. Till then, Jai Hind, Jai Bharat.